All right, hello and welcome to this evidence video capsule. This is, I'll be honest, a complicated one. It is not an introductory capsule. You need to have a basic understanding of a few of the rules of evidence before digging in here. I would certainly go look at my capsules on authenticity and even those on admissions that are admitted as an exception to the hearsay rule before digging into this one. But I'm telling you, this is really important. And I'll give you the basic overview of what we're going to discuss here. In a nutshell, it's this. The accused makes a statement. And when the accused makes a statement, it is usually admissible against him or her in a criminal proceeding. I'm leaving out things like statements made or confessions made to police. It's just, let's assume the accused makes a statement. Okay? And that is usually admissible against him as an exception to the hearsay rule. Now, what do we do where the accused disputes that he or she made the statement? Because what makes that statement admissible is that it's an admission. So in effect, the accused is disputing the admissibility of the admission by saying, I didn't make the statement. The law in this area is very complicated, and the reason it's complicated is because an accused person, in a nutshell, should not have to face a statement if he or she didn't make it. Again, what renders it admissible is the fact that the accused made the statement. So the issue is, should that statement go to the jury if the accused disputes that they made it? This is a difficult problem, and it's a problem that has caused a lot of issues in the case law. So I'm going to dig into it and try and decipher when should a statement be admitted as an admission when the accused disputes the identity of the statement maker.
And right out of the chute, the case that got me interested in this and really thinking about it is an interesting, very short case from the Ontario Superior Court of Justice. So if you have a moment or two, I advise reading this case. This capsule will make, this blog will make a lot more sense if you've read the case. But I will try to summarize the main issues at stake here. And just let me say that the case, I think, sends out a pretty important lesson about the way we can get confused where there are multiple burdens required to be satisfied when you are trying to tender a piece of evidence, and how easy it is to get confused about the different issues that need to be resolved. Really requires a careful thought about the evidentiary principles at stake, or you can see how things can go wrong. At least I think they went wrong in this particular case. So let me put the issue in context for you here and set out the case that sort of is the precursor to the case we're going to discuss, which is Evans. Many of you might be familiar with Evans. There are a lot of interesting issues that are at stake in the Evans case from the Supreme Court of Canada, but the most important for our purposes is that it sets the standard of admissibility for a statement when you're not sure who made the statement. So let me explain by showing this factual scenario. This person, who the Crown is alleging is the accused, goes and buys a car from this person, okay? And there are some details in the statement that are useful, that provide some evidence that the statement is made by the accused. The car that is purchased, so we know there was a car purchase, and we know that this person here sold it, okay? So the car is purchased, and that car plays a role in a robbery. No doubt about that either. But the issue is who bought the car. And the question is whether or not the statement at the time of the purchase of the car can be used against the accused. Because the problem is this witness cannot identify the accused, saw him only briefly, doesn't matter why, can identify the accused. But the question is whether the details in the statement can be used against the accused. And we get into some tricky issues of hearsay here, because what the Crown wants to do is use the details in the statement against the accused. And I won't bore you with what happens in Evans because it's not totally relevant to what we're discussing here, but essentially the majority of the Supreme Court says, well, most of the statements that were made were not being used for their truth, so as a result they could use them to identify the statement maker. They had a circumstantial guarantee of trustworthiness, they had a circumstantial relevance, and as a result you could use them against the accused, and once you can identify the accused, it was up to the jury to decide whether or not the accused was in fact the person who bought the car. That's the important aspect of Evans, but it's not really what's critical for the case that comes next, which is Daly. what the evidence what we have in this case, the case is a kidnapping, and as far as I can tell, the case is pretty sparse on details. The issue that needs to be proven is whether this car at this particular time contained the accused. And all we have is a traffic stop. It's essentially one of those carting stops you've read about, and the police officer asks the accused for his or her name. The accused is in the back seat, not driving. Gets the name, gets the address, and it happens to match the accused, but no identification is shown. So the police officer can provide a basic description of the accused and testify to what was said, the information in the statement that corresponds to Daly. So the police cannot, authoritatively say that the statement is that of the accused, but they can partially describe him and try and have the statement used for their purposes. So the question in Daly is effectively this. Some really juicy evidentiary issues. Is the statement admissible? That's number one. So can this statement be admitted at all? Second of all, if it can be admitted, what can it be used to prove? That's another interesting question. Then there's a third question that I'm not going to discuss, but it's on the table, as you'll see in a moment, whether or not it's voluntary. And then the question underlying all these questions is, what is the burden just to have the statement admitted at all? And effectively, in a nutshell, the issue is this. The accused says, it's not my statement. The accused wants to disavow, the same as in Evans, it's not my statement. So what is the burden of proof to admit the statement against the accused in this case? Here are the arguments, okay? Really complicated. Both sides agree that voluntariness needs to be proven beyond a reasonable doubt by the Crown, and that's not an issue. But they disagree upon the nature of the test that needs to be stated in order to admit the statement at all, before you even get to the voluntariness question. The Crown suggests that all that needs to be done is shown that the statement is authentic. And then the question of whether the statement is that of the accused is a question for the jury, or in this case, it's a judge-alone case, the judge deciding as the trier of fact as to whether or not the statement was that of the accused on a balance of probabilities. Now, the defense makes a different argument, saying that the issue of who made this statement is so critical to this case that it needs the highest standard of proof beyond a reasonable doubt. In other words, you cannot admit an admission against the accused, that is an inculpatory admission, unless you're certain beyond a reasonable doubt that the accused made it. I think both sides are wrong. And I'll tell you why, simply by getting rid of one of the defense's arguments that, in my opinion, is a bit silly, the idea that proof has to be beyond reasonable doubt. There are very few issues in the law of evidence that require proof beyond a reasonable doubt, and there's really no need to augment the standard of beyond a reasonable doubt in this way. So I think what happened here is you have the defense putting up an argument that's kind of silly. There's really no authority to suggest that proof should be beyond a reasonable doubt as to who made it. The only beyond a reasonable doubt standard we have is this one, and this is to protect an important right and recognize the imbalance between the state and the accused when they're in custody. Normally, evidentiary issues are decided on a balance of probabilities. And that is the interesting question here. The Crown puts forward a pretty interesting argument about the way in which we need to deal with the statement. One, an authenticity test. Two, the trier of fact deciding whether or not it meets the balance of probabilities, and if it does, then it can be used, in any way that the trier of fact sees fit once you're through that standard. I think both sides are wrong, and I'll show you how they reached this decision or how they got into this, because I think it gives us some interesting things to think about when we're looking at who bears the burden of establishing that certain pieces of evidence should be admitted. And by the way, in case you're confused about this, I'm going to talk about authenticity in a moment, but essentially the Crown is arguing it's a two-stage process. One, that there is authenticity to the statement. There's some evidence that it was made by the accused. And once this is done, it passes over to the jury, or the trier of fact in this case, which is the judge, that the accused made it on a balance of probabilities. And while I am going to tell you that I don't agree with this approach, there is a reason why the Crown made this argument. This argument isn't spurious. It's essentially an argument that is based on the Evans case, which I want to dig into in a bit more detail. Evans essentially governs the situation in which admissions that are disputed, in that the identity of the maker is disputed, can be admitted. And let's look at what Evans has to say. So Evans is an important case for a number of different reasons. It sets out a lot of important propositions. And the first of these is that when people contest aspects of admissibility, those aspects that relate to admissibility have to be decided by the trial judge. So essentially, the trial judge, as the judge of the law, has to answer whether or not the evidence is admissible. And that's the first question. Is the evidence admissible? And the court goes on to say, and this is still good law, where there is a factual issue that has to be resolved, a voir dire may be required, and the applicable standard, leaving aside the voluntariness rule, is a balance of probabilities. So whenever there are disputed questions that relate to the aspects of a piece of evidence, those need to be resolved by the trier of law first, before getting turned over to the trier of fact. So that's the basic starting point in Evans, and I think there's two propositions here. That's one, trier of fact versus trier of law, and number two, what is the applicable standard? But the court goes on to point out there's an exception to that standard. And the exception relates to the law of authentication. And the reason for this is that authentication is a problem in a lot of cases. And the basic problem with authenticity is that before a statement can be admitted, before any piece of evidence really can be admitted, the court needs to have some assurance that it is worthy of going before the trier of fact. And let me be clear that this rule of authenticity has nothing to do with relevance or probative value or anything. The question with authenticity is a very simple one. Is this evidence what it purports to be? Okay? And if it's not, the court shouldn't even bother with it. But let me be clear. Authenticity is an exceptionally low threshold, and the reason for that is we don't want to deprive the trier of fact from making decisions about whether something actually is what it appears to be. So we set a pretty low standard to begin with for authenticity. So essentially, to sum all this up, what the court seems to say in Evans is this. For basic questions of evidentiary admissibility, where you are dealing with a rule of evidence, the standard is a balance of probabilities to have something admitted. But where you are dealing with authenticity, it is a lower standard. A different view is merely whether there is some evidence of authenticity. In other words, you don't need to put it to the balance of probabilities. Some evidence is good enough to win the day. Now, I don't know how you're feeling so far, but it seems, I'm hoping that you've got a basic understanding of the different burdens that take place, most factual questions that need to be resolved, balance of probabilities, whoever is adducing the evidence, in this case, the Crown. Authenticity, lower standard of evidence. But then Evans throws in a couple of lines that I think get everybody confused. So let me stress, these are direct quotes from Evans. If there is some evidence to permit the issue to be submitted to the trier of fact, then the matter must be considered in two stages. First, the balance of probabilities threshold, and then, once the threshold is met, the trier should then consider the contents of the statement along with other evidence to determine the issue of innocence or guilt. And right here, I think, in the way in which this is worded, it sets the stage for some confusion because it appears to say something that is different from what we were just talking about. And let me show you how the judge in Daly, prompted by the Crown, interprets this case. And this is Judge Fairburn, who I have a great deal of respect for. Judge Fairburn is an excellent judge. And essentially what Justice Fairburn says is this. Here's the key. If there is some evidence to permit the issue to be submitted to the trier of fact, the matter must be considered in two stages. She reads this as saying, well, this is stage one. And if the some evidence is permitted, then the matter goes to the jury. A preliminary determination for the jury. And then, when this threshold is met, the jury can then use it with other evidence to determine the issue of innocence or guilt. So essentially, Justice Fairburn reads this as importing a different standard than other issues of evidentiary admissibility. In other words, where the only question is, was the statement that of the accused, only the some evidence threshold needs to be met by the trial judge. And this is Justice Fairburn's ruling. Leaving aside voluntariness, in a jury trial, the judge admits the statement if there's some evidence that the accused is the declarant, and then it's up to the jury to decide as a secondary legal question whether the Crown has established on a balance of probabilities that it was the accused who actually made the statement. Now, let's cut a long story short by saying I think Daly is wrong, as my cartoon figure says right here. But I can tell you that I had to think a lot about it. I had to read Daly several times and really dig through Evans just to show how complex this issue can get, even for law professors. But I'm going to tell you exactly why I think Daly is wrong, requires some unpacking of the issues, and really some deciphering of what the Supreme Court said in Evans. But mostly I'm guided by this principle. Juries should never, or I should say almost never, perform evidentiary decisions. I know that juries do occasionally do this, such as, for example, in the context of the co-conspirators rule. But by and large, the courts have repeated over and over again that it is a bad idea to give the juries multiple thresholds when they're trying to decide how to use evidence. It just complicates matters. And we should never complicate matters for the jury by saying to them, okay, well, first of all, we're going to explain the balanced probabilities threshold before you even consider this evidence at all, and then you can go on, if you've satisfied that, and consider the evidence beyond a reasonable doubt. It's just too complicated. The evidentiary decision is really one for the trial judge, and if it's disputed whether or not the evidence was the statement of the accused, it should be left to the trial judge to make that determination. So this is a policy matter, but now I'm going to go back and interpret Evans to show you why I think legally the decision is wrong as well. So here's the problem. That excerpt that the judge pulled out from Evans, and I'm going to show it to you in just a moment, gets the issues all confused. The real question, as I see it, is that the burden to admit statements in this scenario depends on why they're being adduced. And what was going on in Evans was that the statement in Evans was being used for non-hearsay and hearsay purposes. And there's a difference. Because when you are admitting it for a hearsay purpose, you can only admit it for a hearsay purpose if it falls under an exception to the rule. In this case, the admissions exception. And the idea is that if you're going to admit it under the admissions exception, you need to prove that the admissions exception exists based on the facts in the case. Whereas, when you're interpreting it for a non-hearsay purpose, you're not trying to rely on any other rule of evidence. If the evidence is relevant, it's admissible. And all that has to happen is that it is authenticated. In other words, whether or not you need to use one burden or the other burden depends on why they are being adduced. And let me show you what I mean. So just a quick refresher course. The admissions exception to the hearsay rule, which allows one side to tender confessions against the accused, and objections to hearsay are overruled because the principle underlying the hearsay rule is not being breached. The person who made the statement is here. And this is the reason why the admissions exception exists. If you want to ascertain the truth of the statement, call the person as a witness. But this exception and this rationale only applies where the statement is that of the accused. And that's why the basic threshold to have the admissions exception exist, because hearsay is prima facie inadmissible, is on a balance of probabilities. Where you are admitting the statement of an accused for a hearsay principle, you bear the burden of proof of showing that the admissions exception applies, which means you can show on a balance of probabilities that it was the accused who made the statement. Now, I think Evans is a little sloppy, but if you read the totality of the judgment, you see that the first part of the case, what they're talking about is, should the admissions exception be used? For that, balance of probabilities. Where there is evidence to suggest that a statement is just being adduced for a non-hearsay purpose, all that needs to be proven is authenticity. So, let's put it this way. Technically, the authenticity rule applies in every circumstances. So what the court is saying here is not strictly wrong. This here, this first bit, is the authenticity requirement. If there is some evidence to permit the issue to be submitted to the trier of fact, authenticity. Then a preliminary determination must be made as to whether the Crown has established on a balance of probabilities. But there's nothing in here that says that it's not the trial judge who shouldn't make that opinion. The trial judge should make that determination. First, authenticity. Second, whether it's an admission that can be used against the accused. And finally, if this threshold is met, then it goes to the trier of fact to say whether or not it was the statement of the accused and whether it can be used in that particular way as a finding of fact. Yes, I warned you, this is a little bit complicated, but to simplify it, I would do it this way. Makes sense to me to do it this. First question, Why is the statement being tendered? And by the way, in case you're wondering, we haven't talked a lot about Daly. In Daly, it was being used for a hearsay purpose. Think about what the statement was. I am Mr. Daly. And what is the statement being used for? I am Mr. Daly in this place at this time. It's a clear hearsay purpose, and no one denies that in Daly. Therefore, it's being used as an admission. The hearsay exception must be proved on the balance of probabilities by the Crown. Where it's a non-hearsay purpose, I would just simplify, where it's a hearsay purpose, I would simplify Evans. If I were the Supreme Court dealing with this again, I'd just remove all that discussion against authenticity, because the authenticity test is essentially swallowed by the admissions exception. In other words, the admissions exception is harder to meet on a balance of probabilities, so just stop talking about some evidence at all, because there's no need to get into it for that purpose. Where the statement is being tendered for a non-hearsay purpose, then all that has to be is some evidence that it belongs to the accused. If you're not trying to tender it under an admissions exception, the basic rule of evidence is that the jury should determine whether or not the statement is that of the accused and not the judge. The only reason it's different under this situation here is because one party is trying to use a hearsay exception, and when they're trying to use a hearsay exception, they bear the burden of proof. I am certain, I'm guessing, I was even confused at times, that some of you were confused by this, but it's a really important, even though it's a technical, evidentiary issue. I hope it will help you if this situation comes up in your courtroom, and for now, I'll leave it there. Have a great day.
To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.